Welcome to today's webinar on drinks producers and Scotland's deposit return scheme, navigating roles and responsibilities. For those of you who don't know me, my name is Charles Livingston. I'm a partner in the Government Regulation and Competition team at Brodie's, and I'm joined today by Grant Strachan, who's a Senior Associate in our Commercial Services unit. And Grant and I are also both members of the firm's cross-practice food and drink group. The DRS, the next slide has an overview of that. It's set out in the Deposit and Return Scheme for Scotland Regulations 2020. Slight health warning if you're looking those up. They will be amended either before or at the point they come into force. So there are amendments pending to those that even if you're on the latest available option on legislation.gov, you won't necessarily see exactly what it's going to look like when it takes effect. So if you are Googling it, just that health warning about the regulations, but it sets out the legal requirements of the scheme. And these are regulations made by the Scottish Government. Put simply, the DRS will introduce compliance obligations, mandatory obligations for pretty much everybody in the supply chain. So producers, importers, wholesalers and retailers, and that includes online retailers and the hospitality sector, in respect of the vast majority of drinks that are sold in Scotland in single-use containers. And I'll speak in a moment about what products are within scope. I should say, if you have an interest in the DRS as a retailer, obviously many producers also have retail operations. We do have another webinar specific to retailers tomorrow. So if you are not already signed up for that, you should be able to sign up for it at the same place you signed up for this one. And if not, you'll just find it on the Brodie's site. But the overriding objective of the DRS is to increase recycling rates for those containers that are in scope, increase the quality of recycling to encourage what's called closed loop recycling, so to minimize, if not remove, waste from the supply chain, and to reduce litter by incentivizing the taking of in-scope drinks bottles and cans to somewhere other than a public bin at best, and public park or on the street at worst. Is essentially a form of extended producer responsibility. So the idea of the DRS is that ultimately, when the product is empty, it will find its way back to the producer, who will then be responsible for disposing and recycling it. That extended producer responsibility is the phrase we're using. You may hear polluter pays principle being used in more political discussions, different ways of describing the same thing. And the DRS scheme will go live on 16th of August 2023. To anticipate a question that many of you may be thinking of asking, there has been a clamour for that to be extended from industry. We're not blind to that. There's been a report commissioned by the Scottish Government to say that there are significant risks of the scheme being ready by that date. We're not really going to speculate about whether it will go live on the 16th of August, because we see our role as to let people know what risks they're going to have to deal with, what compliance obligations they're going to have, and based on current information and statements coming out of the Scottish Government, 16th August is the go live date. And until that changes, our advice to anybody who asks us will be to plan on the basis that the 16th of August will be the relevant date. So the mechanics of the DRS scheme, the fundamental principle behind it is that a 20p deposit is placed on an item of packaging, and essentially follows that item of packaging at each stage of the supply chain. Although in truth, the 20p moves in the opposite direction from the product itself throughout. But ultimately it gets returned to the customer when the item is returned to the producer via a dedicated scheme. It's the same 20p deposit for containers of all sizes and regardless of the in-scope material from which they're made. And the deposit flow, at least, is intended to be cost neutral. And what that means in this context is that ultimately nobody should be left 20 pence out of pocket. So by the time the product finds its way back to the producer, the 20 pence should similarly have found its way through the system, and nobody is 20p poorer than they would have been otherwise. Not going to pretend it's cost neutral in terms of its compliance costs or its cash flow implications or anything like that. Those are certainly real and potentially significant. But when we're using cost neutral in this context, that's in relation to the 20p deposit itself. So to give you an illustrative example of how the deposit moves through the supply chain. So we're assuming in this example that we have a producer who's signed up with the scheme administrator. And don't worry, Grant will come back to that concept. But it's simpler if we assume the scheme administrator is involved. So the producer pays a 20p deposit to the scheme administrator for each bottle or can that it puts into the supply chain for sale in the Scottish market. The producer then charges, and we assume there's a wholesaler in this supply chain, charges the wholesaler the 20p deposit on every bottle or can it sells to that wholesaler. So the producer is now all square. The wholesaler then charges 20p deposit on every bottle or can sold to the retailer. So the wholesaler is now all square. And then the retailer charges the consumer the 20p deposit on the bottle or can that it sells. So the retailer is now all square and the consumer is the one holding the deposit. The consumer gets their deposit back if they return the empty bottle or can to a retailer or to another return point. And we'll deal with retailers and return points in more detail in tomorrow's webinar rather than today. At that point, the consumer gets 20p back and they are all square. So they get that back from the retailer. Then the final step is the scheme administrator arranges to collect the article. And at that point, the retailer gets the 20p that they paid to the consumer back. So this is the original 20p that came from the producer to the scheme administrator, then ends up in the hands of the retailer. So at each step, the deposit goes in the opposite direction to the product itself. Okay, moving on, the deposit charging obligation, that arises when the article is essentially first placed on the market. That's not the statutory language, but that's how we would describe it. So when it's first put into the supply chain for sale to consumers in Scotland, and it's then charged at each subsequent step in the supply chain. And you can see the language of regulation 5.2 of the regulations. So any person who markets, offers for sale or sells a scheme article in Scotland must A, charge a deposit when marketing, offering for sale or selling a scheme article in Scotland. There are then other obligations under B, which we'll come back to. But that deposit charging obligation applies at each stage of the supply chain. So whoever is marketing, offering for sale or selling a scheme article in Scotland has to charge that deposit. And it's worth just being very clear that the 20p gets charged on each individual item. So if you have a multi-pack of 6 cans, then it's 20p on each can. So the deposit amount for that unit is £1.20, and the 20p then follows each individual can. So if they get returned one at a time, the 20p's get returned one at a time. There are some exceptions to that obligation to charge a deposit. So export shops, which is a statutory term, duty-free, that sort of thing. Articles that are marketed, offered for sale, or sold exclusively for consumption on the premises of sale. So if you get a bottle of beer in a pub and it's an on license, so you have to drink it on the premises, the 20p deposit does not get charged to you as the consumer. It sits with the retailer in that particular supply chain, and the retailer, the pub owner, gets 20p back when they return the item into the process for recycling. And articles that are intended for retail sale outside Scotland do not have to have the deposit charged on them. So if you run a distillery, for example, and you sell, you're still within Scotland, you're handing over some of your product, but that product is then intended for export, you don't need to charge the deposit on that. So ultimately, it's really intended to capture things that are going to be sold to consumers in Scotland. So the products that are in scope, and the term for this is a scheme article, that's the statutory term. That is any drink, alcoholic or non-alcoholic, that meets the conditions set out on the slide there. So it has to be contained and sold in packaging that is made from PET plastic, glass, steel, or aluminium. So that's the majority of soft drinks, alcoholic products. Really, the only thing that's outside scope is likely to be milk. So milk, the sort of plastic milk bottles, those are made from HDPE, usually made from HDPE plastic. So those aren't within scope. And treated cardboard, like your Tetra Pak type of containers, those are also outside of scope. The packaging has to be designed to contain between 50 ml and 3 litres of liquid, so that's big range, and it's intended to be sealed in an airtight and watertight state at the point of sale. The customer must be unable to return it to its point of sale state by subsequently, so they can't make it airtight and watertight again. So the cracking noises when you break the plastic on the lid of your plastic bottle, you're not able to return that item after you've done that to its original state. And the packaging also has to be single-use packaging, so not intended for refill, etc. That's a point all by itself, which we don't have time to get into today. So that's the first condition. It's the type of packaging. The item has to have been first made available by the producer. So this is the sort of the first step that the item has taken into the supply chain, to be marketed, offered for sale, or sold on or after the 16th of August 2023. We'll come back to what that means, but essentially what it means is that if items get into the supply chain before the 16th of August, the DRS obligations do not apply to them. They can continue to circulate, but the DRS obligations don't apply to them, and they're not eligible for deposits if they're returned. And then the third criteria is that the product must have been made available by the producer to be marketed, offered for sale, or sold for the purposes of its retail sale in Scotland. So that means that the producer has to have said that this particular unit of my product is for sale in Scotland. Now, if that sounds unusual and possibly difficult to manage, then you need to know that it is backed up by a criminal offence. So from the 16th of August, it will be illegal to market or offer for sale or sell to a consumer in Scotland an article that meets conditions 1 and 2. So it's made of the right type of packaging, and it was first put into the market on or after the 16th of August. But if it doesn't meet condition 3, so it's not an item that the producer had identified as for sale in Scotland, then it is illegal to sell that item in Scotland. Essentially, that's an anti-avoidance provision to try to ensure that products, the only products sold in Scotland, are those for which the deposit has been paid into the system. So that is a criminal offence, and it's punishable by a fine. There is a defence of reasonable precaution, having taken reasonable precautions and exercised due diligence to avoid committing the offence. So obviously it may be difficult for a retailer at the end of a supply chain to know whether the producer had intended a given product for sale in Scotland. But since we're today talking about producer responsibilities, that defence is probably unlikely to be available. So if you are a producer and you are selling product into Scotland, that product will need to have been specifically allocated by you for sale in Scotland, with a view to it forming part of the DRS scheme. Now that creates potentially significant logistical challenges about labelling and barcodes and things like that, which Grant will return to, possibly also contractual provisions about, or contractual requirements about specifying to your own customers what items are for sale in Scotland, and possibly what items aren't for sale in Scotland. So we will come back to that. But I'm now going to hand over to Grant to talk about who a producer is for these purposes.
Thank you, Charles. So yes, I'm going to be covering the concept of a producer who would fall within the definition of a producer, and also some of the core producer obligations under the 2020 regulations, and which are also mirrored in the producer agreement with CSL, the scheme administrator, which I will come to shortly. So firstly, Regulation 6.1 of the 2020 regulations defines the concept of a producer, and it refers to, for scheme articles being branded in the UK, the producer is the brand owner. There's then a subsequent definition of brand owner, turning to 6.3, which defines that person as a person who in the course of a trade, business, craft or profession puts a name, trademark or other distinguishing mark on a scheme article or scheme packaging, and by which that person is held out to be a manufacturer or the originator of the scheme article, and branded is then to be construed accordingly. If the scheme article is branded by a brand owner who sits outside the UK, the producer is deemed to be the importer. And then again, under Regulation 6.3, the importer is then defined as the person who first markets, offers for sale, or sells the article in the UK. There are also some situations whereby potentially a retailer could find themselves fulfilling producer obligations. So for instance, if the packaging of a product scheme article is filled and sealed by a retailer and then ultimately sold to a consumer for off-premises consumption, then that retailer would be deemed to be the producer of that particular article. Online sales are captured here under the regulations, and online sales can actually be captured. So for an online retail sale to a consumer in Scotland, if that article has not previously been sold in the UK, then the website operator would also deemed to be the importer and thereby fall within the scope of producer obligations. So in terms of the requirements, a producer must register with SEPA, the Scottish Environmental Protection Agency. Indeed, any producer that is marketing or offering for sale or selling any of the producer's scheme articles needs to be registered through SEPA. As Charles mentioned, it is illegal to sell a scheme article to a consumer if the producer is not so registered, and indeed the 2020 regulations carry a criminal offence. Now, a producer can then discharge its statutory obligations under the 2020 regulations either directly or through engaging Circularity Scotland as a scheme administrator. Now, it's important to point out that it's expected the vast majority of producers will engage CSL as a scheme administrator to fulfil its obligations under the regulations. If a producer wants to go it alone and do that independently, there are also specific requirements that it needs to discharge, including providing a business plan that satisfies those requirements and whereby it can demonstrate that it has the resource and capacity to fulfill the various obligations under the regulations. On timelines, the timelines are actually now very tight. The window opened up on the 1st of January, but producers need to register and all applications must be made by the end of February, so approximately in 5 weeks' time. And Circularity Scotland, CSL, has a deadline of the 17th of February in which to begin the process of registering through them. The requirement is to have a single registration per producer each year. So there's going to be an annual renewal of registrations, and the annual fee is fairly small at £365 for producers with a turnover in excess of 85,000. So if we look to some of the core producer obligations, there are very specific disclosure and reporting requirements. So in this situation, if we assume that producers will be engaging CSL, there's a requirement to collect and keep records of scheme articles made available for the Scottish market. CSL will then support that producer to arrange for the collection of empty scheme containers, communicating with the retailers on return point operators and how to handle the scheme packaging, and then ultimately, as Charles mentioned, in the circularity flow, reimbursing the collecting retailer with the 20p deposit. Retailers, and we'll come to this in more detail in tomorrow's webinar, but retailers are also entitled to command a reasonable handling fee that is reflective of the compliance and resourcing requirements that a retailer needs to set up to comply with their own requirements under the scheme. If CSL is appointed, the producer is required to keep records and indeed provide that information as CSL may require. Compliance failures under the scheme are, as we've mentioned earlier, criminal offences and potentially cancelable, and could result in the cancellation of a producer registration. There's also differing levels of producer fees, and that has been subject to further consideration. And indeed, there was an announcement just towards the end of 2022 where the producer fees were reduced, but that's we've listed below the applicable fees. It's also worth noting that whilst all of the producer obligations are set out in the 2020 regulations, these are also mirrored in the producer agreement that a producer would need to sign up to in their engagement with CSL. So that producer agreement is now available. We have reviewed those terms, and there's very detailed metrics there around reporting requirements, as well as some of the product labeling and barcode changes, which we'll turn to now. So the first point to emphasize is that, and this is reflected in the SEPA guidance, is that there is no mandatory requirement to change the labeling on specific scheme articles, but in practice, that is ultimately going to be the most practical and effective way to maintain compliance. Ultimately, producers need to ensure that all scheme articles can be intended for marketing in Scotland are traceable through the supply chain, and indeed that all SKUs that are sold throughout Scotland are traceable, and that the applicable producer fees can be charged for those specific articles. So if a product packaging is not distinct for items that fall within the scope of the DRS, so if producers are using a UK-wide barcode rather than a DRS-specific one, they will have to pay a surcharge on top of the producer fee for each container. And indeed, the producer agreement does contain very specific detail around the type of barcodes that would be required. They follow an EU specific format for what would be an acceptable form of barcode labeling. If there is SKUs that are UK specific, and there's no differentiation between UK and Scotland specific products, i.e. they cannot be traceable, the surcharge could be levied, and ultimately the surcharge is intended to mitigate the direct risk associated with the use of UK-wide SKUs circulating on the Scottish market. So effectively, you would have non-compliant scheme articles, and that is ultimately the purpose of the surcharge. The surcharge is a fee that would be applied by CSL based on the declared volume of the UK-wide SKUs placed on the market by producers, and it's ultimately calculated to reflect the increased risk of fraudulent or unexpectedly higher returns. Currently, the surcharge is set at 5%. The language used in the producer agreement is it's 5% in year one of the deposit value plus a weighted return point handling fee. That will be subject to review as the deposit return scheme rolls out, and it is going to be reviewed annually. So turning to information disclosure obligations, and I'll pass back to Charles to run through some of the applicable requirements and carve-outs that apply to scheme and non-scheme articles.
Thanks, Grant. So there are various obligations to display information. The first one will be the most common one. This is where an article is subject to the deposit. It is a scheme article. So a person marketing, offering for sale, or selling a scheme article in Scotland must, other than in the exceptions noted at the bottom of the slide, in any place where a scheme article is displayed for sale, clearly display information indicating that the article is a scheme article to which the deposit charging obligation applies, and the deposit amount. Now, that concept of scheme articles being displayed for sale, that's most obviously relevant at the retail end. It's on display in the shop. But even if you're not retailing to consumers, if you are nevertheless displaying your products for sale, so if you're a producer, you're displaying products for sale to a wholesaler or to a retailer, a B2B transaction, you still need to display this information. You still have this obligation. I said we'd come back to the concept of a non-scheme article, which means a product that is in the relevant packaging and was made available for the purposes of sale in Scotland, but was first made available prior to the 16th of August So it was in the supply chain before the 16th of August. If you are marketing, offering for sale, or selling from that date, such an article, you must communicate at the point of sale that it is not a scheme article under the regulations and can't be returned for a deposit. Now, this is subtly different. It's not about displaying information. It says that you have to communicate at the point of sale. So even if you're never displaying your product, you may need to communicate to the buyer that what they are buying is not a scheme article under the regulations and that it's not eligible for a deposit. What the legislation doesn't speak to, I'm not sure if it's intended or an oversight, is it doesn't speak to an article that is in relevant packaging, but was made available prior to the 16th of August and was not made specifically available for sale in Scotland. So it's in the UK supply chain before the 16th of August, was never really intended for Scotland, but nevertheless finds its way to Scotland. That's not a scheme article, so the deposit doesn't apply to that. But it's not clear whether this information obligation applies. So that may be more of a headache than any of you really want to absorb, but just flagging that the legislation is possibly not quite as tight as it might be on some of these principles. And there's then the concept of a non-Scottish article. So that used the relevant packaging and it was first made available by the producer for marketing, sale, etc. on or after the 16th of August, but not for the purposes of retail sale in Scotland. Now, such a product can still be marketed, offered for sale, or sold in Scotland, as long as you're not doing that to a consumer. So you can still sell such a product in a B2B situation. So that's the example I said before. If you're a distillery and you're selling, so you have whiskey that's in glass bottles, so it uses the relevant packaging, and you've put it onto the market after the 16th of August, but it's intended for export, you are still able to sell that in Scotland in a B2B scenario. But from the 16th of August, you have to communicate at the point of sale that the regulations don't apply and the article cannot be returned for a deposit. Now, I don't know what sort of compliance levels there are going to be with these information obligations, but they do exist and they are backed by criminal liability. So it is just worth having these in mind, and having some boilerplate wording in your contract possibly, or in your invoices that just says these are not covered by the regulations and not eligible for a deposit. Now, if you're selling them to an exporter, the exporter will probably wonder, why do I care? Why are you telling me this? The answer is because legislation requires you to. So that's just an important or potentially important requirement that you should be conscious of. So just before we turn to the questions, we've got a good number of questions, but if you have one you've yet to ask, please do feel free, because we can always come back to you afterwards. So the key takeaways: if you're a producer and you want your products to be capable of lawful sale in Scotland from the 16th of August, then you need to register. And as Grant said, the window for registration is closing very soon. So if you're not registered, you need to act fast. For any given product, it's going to be important for everyone in the supply chain to know who the producer is. If you're in a situation where you are not sure if you qualify as the producer, as Grant defined it, for a particular product, then you need to bottom that out. In most cases, it'll be pretty obvious. If you're an entirely self-contained business, you're Scottish based, you manufacture everything in Scotland and you place it into the market from Scotland, that's going to be pretty straightforward. But if you have more complicated supply chains, there might be a question of who is the producer. Is it the manufacturer? Is it a person who imports product into the UK at what point is it imported, who is the person who imports it, and then there's the whole concept of the brand owner, which is the defined term used in the regulations, which I'll confess Grant and I have been wrestling with internally. That's causing clients a few headaches. So the brand owner, does that mean the person who owns the intellectual property that goes on the product, or is it just the person who arranges for its manufacture? Is it the person whose address is printed on it? What if those are all different people? So if you're not clear about that, just make sure that you do get that straight in your own mind. Producers will need to work out how you're going to identify and separate products intended for retail sale in Scotland, because if you don't do that, then your products won't be capable of lawful sale in Scotland. It's as simple as that. You also don't want to overestimate how many of your products are going to go on sale in Scotland, because you'll have to pay the deposit into the system for each of those products. And if the product ends up going to England and going in a bin in England, that 20p is not going to come back. There are, as I said earlier, cash flow and cost implications, not just in terms of handling the deposit, but also in terms of the producer fees that Grant mentioned and the surcharges if you're not operating non-Scotland specific labeling, barcodes, etc. So you need to be doing those maths. Make sure you get your record keeping in order, because you will have to report. If you're using the scheme administrator, you'll have to report and keep information about how much of your product is being placed into the Scottish market. And anticipate the information obligations that I've just covered. Understand when you're going to be saying the deposit is payable on this item, deposit isn't payable on this other item. So those are our key takeaways. We've probably got more questions here than we're going to be able to get through, but we will do our best. I'll take a couple of simple ones to start with. So Grant, question for you. What if producer's turnover is less than 85,000? So that'll go to the fee.
Yeah, so there's the fee of the 365 only kicks in if there's if the producer's revenue exceeds that sum.
But that's really the only relevance. That's the only thing that threshold is relevant to.
Yes. Mm-hmm.
A question here, if I'll take this one. If a soft drink or water in a container is offered for sale in a pub, is it the pub owner or the consumer who pays the deposit? So just sort of preliminary point, it doesn't matter if it's soft drink or water or if it's alcohol, so it could be beer in that bottle. If it's offered for sale in a pub and it's for drinking on the premises, then the consumer does not need to pay the deposit. That 20p basically remains in the hands of the pub owner, and it's then for the pub owner to get that bottle back once the punter has finished with it, and the pub owner will then return that into the system, and they'll get their 20p back that way rather than by charging it to the consumer. There's a question here, quite a specific fact pattern, Grant, but it maybe goes to sort of a wider theme of are producers liable for products that shouldn't be sold in Scotland but are. So the question that's been put to us is, if a sale is made, so a producer makes a sale to a UK retailer with an online platform, let's say it's an English online retailer selling into Scotland or a Scottish online retailer selling into England. Circularity Scotland have advised that the producer would need to obtain a monthly report from these retailers advising how many units were actually sold to Scottish-based consumers. And in that case, the producer would need to invoice the retailer the deposit charge based on units to Scotland retrospectively, say once a month. Is this allowed? Now, the last part of that is possibly a bit too specific to answer on a webinar, but do you want to cover the point about sort of producer liability and anti-avoidance requirements on producers?
Yeah, sure. So I think the first point to say is that the producer does need to maintain records of all SKUs that are going to be placed on the market. Indeed, there will inevitably need to be a conversation as between the retailer and its distributors or other actors in the supply chain, so that previously, for example, if a producer had SKUs that were and those SKU numbers were reported just for the UK-wide market, there will need to be market differentiation as between England, Wales, and Scotland now. So that's the first point to know. The producer will also have reporting obligations to CSL if indeed they're engaging CSL there. In respect of potential liability for non-compliant scheme articles, there is quite extensive coverage in the producer agreement. So the liability issue that sort of hits between the brows is that potentially a producer can incur uncapped liability. However, producers are also required to undertake a risk assessment, provide a mitigation plan, and also on the barcode labeling point, that compliance step will also provide supply chain traceability. So I think a producer would have a reasonable defense if they're able to say that they have undertaken the risk assessment, looked at the risk mitigation steps, they've got that formula recorded, they've disclosed it to CSL, and they have barcode labeling that differentiates between the rest of the UK and Scotland specific for scheme articles.
Okay. Grant, I'll just tee you up. There's a question there about checking the fees for glass. Do you want to just quickly do the maths on that while I answer a different question? There is a question here about, is there a template for shelf edge label, single price multi-pack, multi-buy or meal deal? Trading standards are not speaking with one voice, CSL, no guidance. I heard it's not a devolved issue. So it's not a devolved issue. Price markings are reserved to Westminster. So that's not something the Scottish Parliament can amend by itself. That's probably more of a retail question. So without wanting to duck it or waste anybody's time, I think it's probably a case of come back tomorrow for a bit more on that. But certainly I know that there have been messages coming out of trading standards about how to comply with the obligation to show the deposit amount as well as the selling price. That's mostly, and for the benefit of the producers, the real tension there is, as well as having to show the deposit, the retailer has obligations to show the selling price to the consumer. Now, obviously, that doesn't necessarily apply further up the supply chain when it's business-to-business transactions. There are particular obligations on retailers there, but remember that producers do have to specify the deposit amount and provide the other information, even if you're selling at a higher level of the supply chain. Question, another one I'll take. Producer makes oat milk, puts it in glass bottles, supply cafes and some retail places. Currently pick up all the glass bottles from cafes and returned bottles. Retail sites take bottles back, sterilize and reuse them. Going forwards, do we need to run the deposit scheme for the retail places but not the cafes, or for both? Our bottles are not single use as we reuse them all. So that question of is it single use packaging? That's going to be the key question for you. I wouldn't want to sort of give you a thumbs up or thumbs down on that without knowing a bit more about your process. But certainly single use packaging has a very particular meaning within the regulations. So at the risk of telling you to suck eggs, I wouldn't necessarily assume that what you think of as single-use packaging is what the legislation thinks of as single-use packaging. But in terms of the sort of cafe retail distinction, if you're the producer or you're upstream and you're selling into those buyers, you have to charge the deposit on both. This is related to the question about what happens if something's sold in a pub. So the deposit goes down the supply chain. If the product is then sold to a consumer for consumption off the premises, the consumer is charged the deposits. The retailer gets the deposit back from the consumer, and it's then the consumer's problem about whether they get their 20p back. If it's sold on the premises, the retailer does not have to charge the 20p, and the retailer holds the deposit at that point. As far as the producer is concerned, the type of customer and how they're going to sell it doesn't really matter. Your obligations are the same at your level of the supply chain, and it's just a question of how things are treated at the point they're sold. So again, I mean, these are questions that touch quite heavily on retailer obligations. So if you do have those sorts of questions, and even if you're not a retailer, just if you want to understand how the scheme works, do tune back in at tomorrow's retailer webinar. So Grant, do you want to just explain what the question is about fees for glass and then just confirm the position? if you've been
Yeah,
able to get the numbers.
yeah. So I don't have the numbers to hand, but it is called out in one of the policy papers in a producer agreement. There is extensive coverage as to what would how they break that down is between the different ranges of products there. So we'd need to look at the factual pattern in a bit more detail and then look at pull up the relevant rates in the producer agreement.
Okay, we can maybe come back to the questioner about that one. Also a question about what happens if I launch a product later this year? Can I still register? I can't do it by the deadline just now. So yeah, so the deadlines that are being spoken about are the deadlines in order to be able to sell as of the 16th of August. So if you're not going to launch your product until December, then you maybe don't need to register by the deadline. But the registration process is going to be very, very, very busy for the first part of this. So it's probably unlikely that, you know, if you're planning to launch on the 1st of September, it's not like you just extend the deadline by 2 weeks and you'll be fine. I think you do need to take account of the scale of the registration process. There's a question about sale via vending machines. Come back tomorrow for that one. Question, Grant, if you want to field this one, what if you have a website selling alcohol throughout the UK? Should you create an option to buy for in Scotland or outside? Are you then hoping the customer ticks the correct option? If they are in Scotland, is it possible to add a sticker for Scotland? So a couple of different questions there. That's at 2:01 p.m. if you want to bring it up and have it in front of you while you answer.
Yeah, so there's a few, as you say, Charles, there's a couple of different limbs to that question. First of all, the way the obligations are written is that it's not consumer facing for a consumer to differentiate between the products itself. So ultimately, if a website owner is outside the UK, outside Scotland, they're selling scheme articles they're selling product as scheme articles into Scotland, and they meet that definition, they would potentially become an importer and would hold producer obligations as an importer. The second limb to the question, if they're inside, is it possible to add a sticker for Scotland? Well, ultimately, to avoid surcharging, you would need to have a differentiation on the barcode so that the stock could be demarcated between Scotland and the rest of the UK. It's not mandatory to add a sticker to the product, but bear in mind that a retailer does need to, a producer does need to have products identified as falling within the scope of the DRS, and then indeed retailers have obligations, which we'll come to more tomorrow, but at a very high level. If you're a retailer, you need to undertake a form of diligence to show that the stock that you're selling is from a producer that is registered under the scheme.
Yeah, and I think that the answer will also change depending on whether you are the producer operating your own website or if you're an intermediary. Because if you're an intermediary, then the producer who sold to you should have told you whether the product is for sale in Scotland or not. Yeah, not straightforward, unfortunately. So there are other questions about, what if you can't tell your drink is going to be consumed on premises or off? So that, just to reiterate, if you're the producer, that's not your problem. So if it's a cafe that will sell a product for takeaway or for consumption on the premises, it's up to the cafe how they deal with that. They can charge the deposit on all of them if they want, and then the person goes and sits at a table, and then they come back to the till and they get their 20p back before they leave the cafe. That's really the retailer's issue. If selling to consumers in a bar or restaurant currently recycle all scheme containers, how's the deposit reclaimed? So again, that's more of a retailer point. So I'll say come back tomorrow on that one. But certainly, the DRS is largely going to replace, certainly for venues like pubs that largely where most of their waste is going to be scheme articles. The DRS process and the collection process under the DRS contract for which has been awarded to BIFA. So that's going to be separate from, with curbside pickup and all the things that operate at the moment. yeah, that is certainly going to be a challenge for bars and restaurants to shift from one model to another. There's a question about duty suspension, which I'm going to put in the too difficult pile, but we'll follow up with you on that one, the questioner for that. Question about risk assessments. Is that for each customer or on each SKU? Grant, too difficult pile again?
Yeah, I'm looking at it again. Well, so the responsibility to register clearly falls with it for the producer. That producer then needs to undertake a risk assessment for all scheme articles that are going to be sold in Scotland, and then each SKU needs to be ultimately registered, so notified to through CSL as the scheme administrator. So effectively, each SKU would need to be disclosed in respect where those SKUs are scheme articles.
Yeah, and I think that makes sense in terms of the policy behind the scheme, because one product may have a much wider circulation within the UK than another product. So even though they're sold by the same customer, so yeah, I think that makes sense. Questions are coming in faster than we can answer them. Can a single barcode be used for different variations of a product sharing identical type and size? For example, can cider A and cider B, if both sold in 75 CL bottles, share one SKU? That's probably not a DRS specific question. I think that would engage other obligations, and I think the answer is probably no. But Grant, what do you think?
Yeah, so the only thing I would add to that, Charles, is that if you're selling, and this is covered in one of the annexes to the producer agreement, that if you're selling multi-packs, for example, the shrink wrap on the outside of that multi-pack would need to have a barcode. But then each of the contents of that multi-pack, so for example, if you're selling a 6-pack of water, each of those items within that, making up that 6-pack, would be registered as scheme articles. Now, my understanding is that you would then have labeling on each of those products that would be recognized as part of that multi-pack.
Yep. Okay. Will producers be allocated a registration number so compliant producers can be identified? Surely help with any due diligence requirements. Yeah, so SEPA is going to publish the register of registered producers. So in terms of downstream operators doing diligence about whether a given product has been produced by a registered producer, the register will be available for that. Let's see, what else do we have? Definition of what's the definition of single-use packaging? So the legislation has its own definition of single-use packaging. So the person who's asked that is anonymous, so I'm not sure we'll be able to get in touch with you about that, but if you drop us a line, then we can come back to you on that if we're not able to follow up from the chat. There's a question about VAT. Grant, do you want to take that one just very briefly?
I think we need a bit more context for that. I don't think there's much we can really.
So we can't really confirm at the moment because it's the subject of much argument. The last I checked, HMRC were still not confirming whether VAT was chargeable on the price including the deposit or not. Obviously, if it's chargeable on the price including the deposit, then that's adding an extra 4 pence of VAT as a result of the deposit being on that item. I know the Scottish Government think that VAT shouldn't be chargeable because that's not the intention, but HMRC seem to. I don't want to cast any aspersions, but I think it's not being resolved quickly. I am conscious of time. Maybe just take a couple more questions. If the product is produced in England and imported to Scotland for sale in Scotland, then the English producer doesn't charge the importer the deposit. So I think there's a misconception there about importer. So that's if product is imported into the UK. So if product is produced inside, if the producer is inside the UK, then that producer has to register. Grant, anything to add on that one?
No, I think that's absolutely right. The only thing I'd say is, yeah, bear in mind that the concept of importer is defined in the regulation with respect to the concept of producer responsibilities. So yeah, it very much, you know, you can have an importer that that will carry producer responsibilities.
Yeah. Okay, as I say, the questions keep coming thick and fast. We could probably be here all afternoon answering them, but I am conscious of everybody's time. If we haven't been able to answer your question live, we will endeavour to come back to you, but if you have a question that you still want answered, then you can see our email addresses on the screen there. As I said, there were quite a lot of retailer based questions there. So if you are interested in the retail element, whether it's because you are a retailer or you just want to understand how your customers are going to have to deal with things, then do sign up for tomorrow's webinar as well if you aren't already. Guys, I will just thank Grant and I'll thank all of you for your time. It's a big topic, it's a hot topic, and if there's anything that we can do to assist you with it, then please don't hesitate to get in touch. Okay. Thank you very much.
Thank you. Goodbye.